Thanks for joining us today, everyone. We'll be getting started in just a few minutes. If you can confirm you can hear us by typing in what state you're from into the Q&A box, we'll get started momentarily. All right, if you're just joining us, do let us know that you can hear us by typing in what state you're coming from into the Q&A box. We'll give everyone just a few more moments and we'll get started. All right, great. It looks like we have students from all over the country, from several states. So let's go ahead and get started. Welcome everyone, and thank you again for joining us for today's webinar. We hope that you're all safe and healthy, and we appreciate you taking the time to be here today. Just a little housekeeping before we get started. We'll be running a live Q&A at the end of the webinar. So if you have any questions during the presentation, please just type them into the Q&A in your Zoom control panel. And if you miss anything, don't worry, we'll be sending around the recording when it's available. We'll also be presenting poll questions, so you'll have your mobile phone ready to text in your answers, or there's a web option as well. My name is Jennifer Sterling, and I'm an instructional designer with the CE Shop, the leading provider of online real estate education. Today, we're reviewing leasing and property management as it relates to your licensing exam, presented by David Forward. David first became a realtor in 1988 and has won numerous awards for sales achievement, along with being named Realtor of the Year, and was a national winner of the Good Neighbor Award from the National Association of Realtors. As a licensed broker salesperson, real estate instructor, and a director for Garden State Real Estate Academy in New Jersey, he continues to be actively involved in real estate education. David's written 15 books, including the textbook Fundamentals of New Jersey Real Estate. Now, without further ado, we'll turn the time over to David.
Well, thank you so much, and greetings everybody from beautiful sunny New Jersey, where all good things happen. As much as I appreciate those kind words, that's about me, and the most important people in the room right now are you. So I'd like to just start off with a little poll to find out just where you are along this road towards your licensure. So did you just start? Can you not even spell realtor yet? Are you almost done? Just let me know really quickly where you are right now. Okay. Well, that's kind of interesting because it looks like it's a couple are still coming in here. And it looks like we're very, very evenly split. Between people who have just started and people who are almost done. So congratulations to those who are almost done. I'll do everything in my power today to make you feel even more confident when you go to that state exam. And to those that are just starting out, don't worry, this is the beginning of an awesome journey that you're going to look back on one day and remember with fondness, I hope, I promise. So you are already aware of quite a range of test topics when you go to that state exam. Some of those are state specific. Some of those are things that you may never use again until several years from now when you decide to come back and get your broker's license and then go, oh my gosh, didn't I learn about that years ago? But more importantly, there are things that you not only need to pass the state exam, but which you'll use every single day in your real estate career. And so let's just jump right in and talk about one of those most interesting and most useful parts of your real estate career, and that is leasing and property management. Depending on the state, they tend to be somewhere around 3% of the exam questions if you're taking the salesperson's license, and a little bit more if you're taking the broker's exam. And so what we're going to talk about today are, first of all, just the real basics to understand the differences between different types of leases and what a property manager is and what we should do and what we probably shouldn't do, and just general things, not only to help you in your career, but perhaps more importantly, on the immediate time horizon, and that is how you can just ace that state exam. So let's go ahead and start off with a definition of property management. When it comes to a person who, let's say, says to you as your client, I'm thinking of diversifying my investment portfolio and I'd like to maybe buy a townhouse and rent it out, that you should be available to be able to let them know what's available, perhaps give them advice, and know yourself what you should do and perhaps what you should stay away from doing. So Property Management 101 would say this: that client, let's call him Joe, to whom you're about to sell the townhouse, wants to buy a property and lease it out. And so he, of course, as we know from our agency law classes, that he is going to be our client. He has three different names here, not one, not two, but three. He is our client, he is the landlord, and he is the lessor. And the question for John is, John, do you want to manage that property yourself, or do you want to give it to somebody else? And he says, well, tell me the difference. Well, the difference is, if you want to manage it yourself, you'll certainly come away with a little bit higher net at the end of the month because you won't be paying a property manager. But on the other hand, the good news is you'll be making more money, possibly. The bad news is you're going to be the one that gets the phone call at 11 o'clock on a Saturday night saying the air conditioning's not broken, and you're going to be the one that has to show up and sit there for 2 hours waiting for the certificate of occupancy between tenants and so on. So it's a real judgment call. I would never say to a client, you should do this or you should do that. I think our job as professional salespeople in real estate is to lay out the options and say, here are the options, positive and negative, for you hiring a property manager versus those that where they want to do it themselves. So in the world of agency, which you already know about, a property manager is a general agent. He's different from the role that would be played when you are representing a buyer or a seller, because then you have a very narrow range of duties that your principal has assigned to you. You're a special agent. But a general agent, a property manager in this case, might be tasked with finding new tenants, getting the CO, doing their credit check, making up the leases, taking the maintenance calls. But on the other hand, the landlord might say, I'll go ahead and collect the rent and I'll pay my mortgage. So it's almost like presenting the client with a menu of services and saying, you tell me which of these services you would like me to take care of, and then off you go. Well, there's a party that we haven't talked about yet. We've talked about the agent, we've talked about the client, but we haven't talked about the tenant or the lessee. And in the wonderful world of agency, that tenant would be considered the customer of the property manager, not the client. And so now we have have everything set out. We've got our client or principal, we've got our property manager or general agent, and then we've got the tenant or otherwise known as the customer. So let's just take a moment here and do another poll. We know about fiduciary duties. To whom does the property manager owe his or her fiduciary obligations? The lessor, the lessee, both of them, or the management team? Okay. And it looks like we knew that we had an exceptionally smart group in the class today, and indeed we do. And so the 73% of you who chose the lessor hit it right on the head. Remember, the lessor is the landlord. An easy way perhaps to remember that, if you have trouble remembering between lessor and lessee, is what is it that the lessor is going to give to the tenant? They're going to give a lease, correct? And so, although this is not really a word in the English language, if you can just imagine the landlord, because he is giving a lease to the tenant, think of him as the leaseor, then that's close enough for government work to remember lessor, leaseor. The lessor is the person that gives the lease and therefore is the principal and the landlord. So you are absolutely correct. We're up to 83% of you that said the lessor is the person to whom they owe this fiduciary duty. Well, let's just take a real quick trip back down memory lane and remember our fiduciary duties. And I honestly think the best memory jogger that I've ever seen is old car. And so the duties that that property manager has to the landlord, to the lessor, are summarized with O, obedience. If the lessor says, I don't want a tenant with dogs in my property, doesn't matter how much the property manager loves dogs or how adorable that golden retriever is that the tenant wants to bring in, the answer is no. We must always be obedient to our principals' wishes and commands as long as they are lawful. L stands for loyalty. And so it's very important that we remember this is the person that has hired us. And so we have a duty to be loyal to that client, in this case, to the lessor. Disclosure is probably one of the most important things in all of our real estate career, whether we're with buyers or sellers or landlords or tenants. Disclosing any material fact is absolutely critical, not only for us to keep our license, but for us to stay out of trouble. Disclosure. If it's something that you think might ordinarily cause a person, whether it's the landlord or the tenant, to have pause in making that decision to move ahead, chances are you should disclose it. Confidentiality of all of those 6 different traits that detail fiduciary duties, confidentiality is the one thing that we carry to the grave. Even after we no longer represent that client, we still have to maintain confidence of the things that they told us that otherwise could cause embarrassment or worse to them. Obviously, there's a lot of money that's going to be transferring between the property manager and the various services that he's outsourcing to, and collecting money from the tenant and passing it on to the landlord. And so it's critically important that a property manager have an accounting system set up so that his records are kept meticulously accurate in case his client ever asks him for an accounting. And then finally, reasonable reasonable care. I know that stands to reason, but it's amazing how many times you hear stories of an agent that went out to show a house and forgot to close the door, or they forgot to turn the heat down when they left and ran up a $200 heat bill. So again, treat the landlord's property as if it was your own property, and you'll never get into trouble. So now that we've had a couple of minutes to talk about fiduciary duties, let's just think about the most basic duties that a property manager has. To whom do you think those duties are owed? Take a couple of seconds and let's have your opinion. Okay, it looks like most of you have voted. I know it's very tempting sometimes in your quest to just share what you know and to just give over the top service and advice to a client. It's very tempting to maybe share an experience you had in the past, but we have to be very, very careful not to advise them on something that's outside of our wheelhouse, as they say nowadays, not to start giving them advice that later could be deemed as having been the unlawful practice of law, or to give them advice on perhaps income tax implications if they're looking at an investment property. And later it turns out that it didn't work out quite that way, and guess who could be held culpable for giving tax advice when you and I have absolutely no accreditation in the accounting field. So as much as we would like to do B or C or even D, you're absolutely right. The 92% of you who said the most important duty is to protect that landlord's investment and to do whatever we can to help him or her produce a profit every year. That's the whole reason the person invested in that piece of property. So since your fingers are on the button, let's just talk for a moment about that property management agreement. It obviously should always be in writing. Otherwise, you run the risk of the old adage that an oral agreement is worth the paper it's written on. So in that agreement that the property manager has with the landlord, with the lessor, of course, first of all, we have to clearly identify the property. We have to set out what the responsibilities are. The landlord has certain responsibilities, the property manager has responsibilities, the tenant has certain responsibilities, and more than anything else, I could describe this whole section, this whole slide by saying, don't leave anything up to conjecture. Don't let people guess or assume that they know what they're supposed to do. Get it in writing. Clear definition of the authority. You need to know what you need to know. Otherwise, how can you really do a good job for your client? Clearly, you're not doing this as a charity, and so the landlord and the property manager have to have it clearly set out as to who is paying whom and for what and when that compensation is due and how it will be paid. Liability is a big thing in the property management field. Unfortunately, a lot of property managers do incur lawsuits, not necessarily always at fault, but it's very important that the property manager has the proper amount of liability insurance, not only to protect the property manager and the firm, but also to mitigate the liability for the firm's client, the landlord. Finally, what about the responsibilities of the parties financially? And we certainly need to be up to date with the various rules, and we have to have in that agreement the Equal Housing Opportunity Statement. And just like a listing agreement, we would need to put on there a beginning date and an expiration date. The expiration date, depending on state law, it could be a year from now, it could be 5 years from now, but we cannot have a blank expiration date on a property management agreement with a client. Okay, so it's time to let your fingers do the walking. Which of the following best describes an appropriate action that a property manager should take when determining rental rates for a particular property? Well, I bet I know what you're thinking. You're probably thinking, well, it depends, David. It depends who's doing the voting. Because if it's the landlord, then she's going to vote for A, because the rental rate should be higher than other properties so she can make a higher return on her investment. But if you're the tenant, you're going to say, no, 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 no. The proper answer is B, because it should be lower than any other properties so that I can get a steal on the apartment that I'm renting. And I certainly would hope that you wouldn't think that it was D, because remember, the question there is based on the qualifications of the lessor. The only person we need to worry about qualifications for, of course, is the lessee. And so to the 90% of the people who said the rental rate should be determined just exactly as if you were trying to determine the proper listing price for a property you were going to list for sale, it should be done by looking at the local market, looking at the historical rentals for similar properties, and then determining from there what the prevailing rent is. So great job, everybody who picked C. All right, so let's then go on and talk about the different types of estates that have that we're likely to be questioned on in the state exam. There are several different types, and let's kind of start at the top of the food chain, if you will. The highest quality interest that a person can have in a leasehold estate, a leasehold interest, if you will, leasehold tenancy. Like I said, everything in real estate has at least two names for the same thing. The highest quality interest a person can have in a leasehold estate is an estate for years. But it doesn't mean that you have to have a lease for years. It simply means this, that there is a definite starting date and a definite ending date to the lease. So quite literally, if you were to rent a property from Airbnb overlooking San Diego Bay for the weekend from Friday to Sunday, yes, you too would have an estate for years, because it had a definite starting date, Friday, a definite ending date, Sunday, and that is the highest quality of estate. Why is it so high quality? Because it protects the tenant, that during that period before the ending date, that is the tenant's home. And the tenant has a very strong bundle of rights to protect them from being kicked out during that period. And it protects the landlord, because the landlord knows that that tenant, theoretically anyway, is locked in to pay the rent and fulfill their obligations for the period of time until the lease has a stated ending date. Well, let's come down one level now in the food chain, and that is periodic estates. And if you think of periodic estates, not quite with that word, but with one of the other terms that's often used, and that is an estate or a tenancy from period to period, that's a really easy way to remember, because if you think period to period, you can think month to month. Everybody's heard about month-to-month leases, and that's exactly what it is. It's where you have a starting date, but you don't have a definite ending date. So if, for example, a person moved into a property on July 1st, then assuming that neither the landlord nor the tenant had given notice to the contrary, on August 1st, it automatically renews. For how long? For the same period, another month. And then on September 1st, nobody said anything to anybody, and it automatically renews. Well, then how long can it go? It could go for 50 years. It's an indefinite duration. It could go for 30 days. It could theoretically go for 7 days if it was a week to week, or it could go until one of them just either gave notice to the other or for whatever reason passed away. So now we come down one more level and we talk about an estate at will. And an estate at will has an indefinite duration, because unlike a periodic estate, it doesn't run for a month. It runs for whatever. It would be a case where father says to son, okay, son, I'm moving to Florida. It's not really the right time for us to sell our property up here in Maryland. So you can go ahead and live there. And until the father says, okay, we're going to sell the house now, son, it's time for you to move out, or until the son gives notice to the dad, then that estate at will continue for years and years and years and years, conceivably, until either one gave notice to the other, or until one party, meaning the grantor or the grantee of that estate at will, were to die. As soon as dad died, the estate at will is over. As soon as son died, the estate at will is over. And then finally, we come down to what we landlords absolutely abhor, because we suffer through this. How appropriate that it's known as an estate at sufferance, because in this case, the person has stayed beyond the time that either we said they must leave or they said they were going to leave. And so they are known as a holdover tenant. Just remember the difference between the two definitions here. The tenant, the person, is the holdover, and the estate, the level of interest that they have in land, is that they're an estate at sufferance. Just one final little point on that. This is different from what some people may be thinking right now, and that is they're a squatter. No, not at all, because at some point, the holdover tenant was legally allowed to live in that property, whereas, of course, a squatter just took it over and never had the legal right to live there. So, okay, get your voting fingers out and exercised. And here's the question. A tenant who signs a 6-month lease that contains a termination date has entered into. Okay. Well, I think I can guess why a number of people said periodic tendency, because you were probably thinking periodic, period to period, month to month, because the question had the term 6 month. But remember, the key term there in the question is contains a termination date. And therefore, if it was a periodic tendency, it would not have had a termination date, would it? It just automatically rolls over at the end of each period, whereas an estate for years, by definition, even if it's 24 hours later, has a termination date. So great job, all those people who picked C. Well, I suspect that most people who are renting an apartment or did rent a townhouse at some point just thought a lease is a lease is a lease. Oh, were it to be so, it would make our job as real estate professionals so much easier. But there are several different categories of lease. Now, if you're going to stick just to residential, you'll probably only ever deal with one. But remember, this is an exam prep class for the exam. So there's very likely to be a question or two on these types of lease. So I'll hope to try and make this really easy for you to understand. When you think of a gross lease is the typical lease that most of us either have now or had at one point when we rented a house or rented an apartment. And that's where the landlord says, you owe me $1,500 a month, and that's it. Now, sometimes the landlord included the water and sewer or the heat and electric. That's not really the point. But you did not have to pay extra for the landlord's snow plowing of the parking lot during the winter. You didn't have to pay extra because the landlord needed to put on a new roof to the building. That's a gross lease. Everything is included, regardless of whether or not you pay your own utilities. A gross lease, the most common type of lease for residential clients. From now on, we're only going to talk about commercial leases. And the first one is a net lease. Well, the opposite of gross profit is net profit. And so it is with leases. A net lease is a commercial lease, for example, with an office in an office building where the landlord says, here's your base rent, but then I'm going to take the cost of maintaining the common area, maintaining the elevators, keeping the public area bathrooms nice and clean every night, doing the snow plowing in the parking lot, paying the insurance for the common areas. Making sure that the grass is cut neatly by the landscaping company. I'm going to take all of those expenses, which we call CAM charges. CAM stands for Common Area Maintenance Charges. I'm going to take all of those charges and I'm going to charge you, the commercial tenant, the proportion of those charges that you occupy of the building. So if it was $100,000 worth of common area maintenance charges and ABC accounting firm on the third floor had 10% of the rentable space of the whole building, then in addition to their monthly rent, ABC Accounting Services is going to get a bill for $10,000, 10% of $100,000, and that will be billed as CAM charges. That's a net lease. A percentage lease is also a commercial lease, and that is where, for example, you open Bubba's Barbecue in the local shopping mall in the food court, and what will very typically happen in locations like that is the shopping center will say, okay, Bubba, we're going to charge you $3,000 a month rent as the base rent, but we're only going to have people standing in line at your barbecue stall because of all the marketing that we do. So we're also going to charge you, let's say, 1% of your sales. And so poor Bubba has no idea what his monthly rent is going to be because although the flat rent, the base rent doesn't change, how much else he pays will go up and down according to his sales. And so no surprises there that they would call that a percentage lease. Okay, let's keep going. And so let your fingers do the walking here. Well, that was easy. 100% of you voted for gross lease, and you are 100% right. Oh, somebody snuck in with a triple net lease right at the very end there. It would be very unlikely for the rental for a tenant in a residential unit to be given a triple net lease. I'd be very, very surprised if that happened. And so the people, the 97% who said a gross lease, yes, absolutely, gross lease, very, very common, the most common. I could almost say 100% of residential property leases are gross leases. Well, we're not quite finished with this topic of leases. Let's continue with a couple of others, and one of them is a variable lease. There's a couple of different varieties of variable leases. This typically would be given to a large tenant who's signed a very long-term lease in a shopping center, Bed Bath & Beyond or Macy's or somebody like that. And if they sign a 30-year lease, clearly the owner of the shopping center is thinking, well, wait a minute, 30 years from now, the dollar that I'm getting in rent today is not going to be worth as much. And what if inflation takes off halfway through that lease period? So to shift the risk, the inflation risk and the cost of living risk from the landlord over to the tenant, they will frequently give long-term tenants a graduated lease. The two different types where it steps up would be a true graduated lease, where the lease would say every 2 years, for example, the rent will go up by 5%. And the other one is a little more complicated. It's called an index lease. And that's where the landlord would have picked some index that anybody can check up on, for example, the US Treasury bond index. And the lease would say something like this: your rent will start off at $5,000 a month, but after January 1st in 2021 and every year after that on January 1st, the rent will be adjusted to the cost of living index plus 3%. And that's an example of an indexed lease. And the final one is probably the longest term lease that you would ever be a part of arranging, and that is a ground lease. It is not unusual for ground leases to last for 99 years. They're usually at least 50 years. And simply stated, this would be the type of lease that a company a big stable company wanted to acquire property, but they wanted to conserve their capital. Let's just say it's a hotel chain. Let's say it's a Hilton hotel. And imagine if they had to go out and spend hard-earned cash for all the land for every Hilton hotel in the country. So they will typically go to the owner of that land and say, look, instead of buying it from you, how about we give you $15,000 a month for the next 99 years. And we'll be responsible for everything. We'll pay the taxes. We'll be responsible for building the hotel. We'll maintain it. And 99 years from now, we'll go ahead and either give it back to you or have some provision in there for us to have an option to renew it. Again, most of us, unless we specialize in commercial, are probably not going to be involved on a daily basis with ground leases, but just remember, ground lease, very long term. They have the right of possession, but not the right of ownership. And it's that long-term tenant's responsibility usually to maintain the property. Well, we've talked about a lot of different types of leases. So let's take a look at what must be present for that lease to be legal or at least to be enforceable. First of all, just like with any contract, you have to have a person that says, I'd like to make an offer of this amount, and a person that says, that sounds fair enough to me, I accept. Sometimes it's called mutual assent, sometimes it's called a meeting of the minds, sometimes it's called offer and acceptance. And then in order for a lease to, because it's a contract, no contract is considered to be legal if it doesn't have consideration. Clearly, in most cases, the consideration would be that they're paying $1,500 a month, but it doesn't have to be. Consideration is anything of mutual value to the parties. So again, going back to that example I used a few minutes ago, Dad could be executing a lease with his son, saying, I'm hereby leasing you my property at this address for, and under consideration, he could say, for mutual love and affection. And that certainly, in most of our cases, is something of great value to us, between us and our dads, or between us and our kids. It must be based on a legality of object. You can't have an enforceable lease that is based, for example, on renting a property to be able to use as a for manufacturing of methamphetamines. That would not be a legally enforceable lease. The parties who are the signatories to the lease must be legally competent. You can't just slide a lease under somebody's nose while they're drunk in a bar one night and say, sign this lease. Then the next day the person finds out they've just signed a $3,000 a month lease. Clearly, they were not legally competent to know what they were doing at the time. And you have to have the reality of consent, right? It cannot be something that is forced on them by somebody standing next to them with a gun. They have to have known what they were agreeing to and agreed to it openly, not under duress. Well, a lot of times, some of the issues that come up with us in real estate have to do with the type of leased premises. So we need to be very clear in that lease to clearly define what's included, what is not included in the leased premises. Do we have, does the tenant have the opportunity to use the swimming pool, or is that something that's going to be extra? What about the security deposit? This is a huge issue that you can get into a lot of legal trouble for. This is not a national issue, so each one of you, I really urge you to learn the security deposit rules in your state. They are vastly different in all 50 states. One state will say the landlord can just commingle it with his regular funds. The next says, no, it has to be in an escrow account. One state says you have to pay interest to the tenant. The next state is silent on that. So what's really important here for both you passing the state part of your exam and also to make sure you don't get your landlord into trouble is to know the law. The rent payments, it obviously has to say in the lease how much the rent is, and just as importantly, how it's to be paid, where it's to be paid, what happens if they don't pay on time. And so again, don't leave anything up to conjecture. Get it in writing in the original lease. What the term is, again, whether it's for a day or whether it's for 10 years, make sure that that is clearly spelled out there. And then any restrictions. And why is that? Because imagine if you just went ahead and was a sloppy real estate agent or property manager and you let somebody sign a lease, they moved in, and then they found out after they were already moved in, went to all the expense of moving, that no dogs were allowed in that subdivision. And suddenly now the tenant is just a little bit angry because they either have to get rid of their dog or they have to go to all the expense of moving their furniture and everything and going to a new property. And the landlord, not for nothing, might then try to sue them for breach of contract. So isn't it better, as the real estate professionals that you are going to be, to make sure that you clearly set out any restrictions on the use of the property right there in the lease before it's too late? Okay, so let's move on. Which of the following statements is true regarding the whole purpose of a security deposit? And sure enough, you nailed it. 100% of the people said D, and that is exactly the purpose of a security deposit. Again, do check your local and state rules on security deposits. So let's move on to the next slide. Property managers and licensees will be working with landlords and tenants should be familiar with landlord and tenant rights under what? Well, this is one of those questions that perhaps I could give you a little advice on the state exam. Because there will be times when you look at the 4 questions and maybe you see more than one that you think is appropriate because they sound familiar. Well, there is no such thing as the Housing and Urban Development Act. You've heard of the U.S. Department of Housing and Urban Development, so it sounds familiar. RESPA, the Real Estate Settlement Procedures Act, is a law that has to do with going to settlement for the purchase of a home. And as much as it sounds impressive, the Uniform Residential Landlord Tenant Act, there is no such thing. And so we are governed under the Fair Housing Act because we have to know and be intimately familiar with the rules dealing with fair housing, how we are to treat persons with disabilities or persons of different race, color, religion, and so on and so on. So the 94% who picked D picked the right answer. Let's go on to the next slide in that case. Which of the following identifies an obligation that a landlord must perform? Well, that didn't take long, did it? Yes, you're absolutely right. The landlord's responsible for making the repairs to maintain a safe and decent housing unit for his tenants. That's absolutely the landlord's obligation, no questions asked, and you nailed it. So let's see if we can get you 3 100% in a row here. Which of the following identifies an obligation of the lessee, meaning the tenant? Okay. So 15% answered D. I could understand why you might say that. And again, the laws change from state to state. But in most states, the landlord does not have the right to just show up and demand to be let into the premises, even though it's her property. They usually have to give reasonable notice. But if you look at A, then there's no question about that. Certainly, the lessee is responsible for complying with whatever laws and ordinance apply to the premises, and they're responsible for violating any of those laws. Okay, since you're doing so well, got an 85%, got that one right. Let's see if we can get get even better than that when we get to the next one. So we've talked about the obligations of the lessor. They have to give what we call the right of quiet enjoyment. That's part of the bundle of rights that a lessee has. They have the right to be able to live in that property and think of it as their home. The landlord doesn't have a right to go banging on the door at 2 a.m., screaming to the neighborhood, "Hey, deadbeat, come on down and pay your rent, you're late again." Right? The lessee has the right to live in a place they feel safe and free from sexual harassment or any kind of other threats like that. The lessor has the obligation to account for payments, whether it's a security deposit or the monthly rent deposit, so that if there's ever a question, that the landlord will be able to produce evidence that he has safeguarded the receipts, the rent payments by the lessee. Obviously, a contract, a lease is a contract between lessor and lessee. So the landlord, just like the lessee, must comply with their side of the lease agreement. And once again, just like the lessee, all laws and ordinances, whether they're of the homeowners association or of the local municipality or the state or the federal laws, certainly have to be maintained by the lessor. Well, let's talk for a moment when we go to the next slide. Let's talk about those lessees' obligation. They have to keep the property safe, clean, sanitary. They have to, it's not their property. They have to safeguard it and avoid anything that could cause damage to the property. If it turns out that there is a maintenance problem or a bug infestation problem, then it's their responsibility to report it to the property manager or to the landlord. If there is an emergency, if, for example, there's a burst pipe, then it certainly is the obligation of the lessee to let the appropriate maintenance people come in and fix it before the landlord's property gets further damaged. Obviously, pay the rent in accordance with the terms of the lease and comply with all the local and laws and regulations and those beyond the local community. Okay, so let's move on with a question. Now you are the leasing agent and you are putting an ad in the local Facebook site advertising your landlord's apartment. What do you think? Which one is okay? Okay. Those that picked D are absolutely right. Any of the others, A, B, or C, certainly could be considered to violate the Federal Fair Housing Act. And so you don't want to just get into terminology like that. If there's no pets allowed, that's one thing, but you certainly don't want to say anything in an ad that would infer that it's limited to people of a certain race or certain religious belief or certain familial status or whatever. So great job, the 91% who picked D. Well, speaking of those fair housing laws, we don't need to be scholars of all the laws of the nation, but we do need to know the most important ones that relate to fair housing. The original granddaddy of them all was the Civil Rights Act back in 1866, which banned discrimination on the basis of race and color, which was a great idea, except that they didn't put any mechanism into the law onto how to enforce it. if they found somebody violating it. So it took all the way for 102 years later until they passed the Civil Rights Act of 1968, which once again affirmed that it's illegal to discriminate on the basis of race and color. And they went and added then a couple more protected classes: national origin and religion. And then over the succeeding years, they have added new protected classes to the Federal Fair Housing Act, which was part of that Civil Rights Act of 1968. Now, you certainly would want to, before you go to your final exam, you would want to get up to date with all the protected classes, not only under the Federal Fair Housing Act, but also under any state laws that you may have in your state, some of which are far more restrictive even than the Federal Act. So remember, there could be questions on both the state and the federal laws, and also I might suggest look at the exceptions to those laws for certain categories of people where they are allowed to discriminate. For example, in some states, in the rental of a room in somebody's private home. The HOPA, the Housing for Older Persons Act in 1995, simply relaxed the provisions that existed prior to that to qualify for people who maintain senior citizen housing communities to legally be able to discriminate on the basis of familial status. In a nutshell, what it says is, in the event that you run a community where 80% of the units are occupied by a person 55 or older, or 100% of the units are occupied by a person 62 or older, then in that case, they can legally discriminate against families with small children in the area. So that is what we call HOPA. All right, well, we are counting down to the wire today. So let's just take a look at some of the issues that really are hot button issues today. One of them is assistance animals. We could kind of break that into two categories. The easy one is for service animals. And a service animal is defined very simply by HUD as only being a dog, and only being a dog that is not a pet, specifically says it is not a pet, and that has been professionally trained. And you all have seen those. If you look at the beautiful golden retriever there, you can see the dog's got a waistcoat around and probably has a badge behind the dog's neck. And so guide dogs for the blind, special service animals that can detect when their owner is having a seizure, and so on and so on. So a professionally trained, certified service animal, which is only a service dog, has complete protection. Nobody can deny rental housing, or for that matter, any housing, because that person has a dog. Neither can that landlord say, well, I'll let the dog come in if you pay a dog deposit, or if I raise the rent. Neither can you discriminate on the basis of breed or size. You can't say, well, I wouldn't mind a service animal if it was a Yorkie, but I'm not going to let you in with that Doberman. So service animals, pretty cut and dried. Emotional support animals are different. With emotional support animals, sometimes called comfort animals, but the proper term is emotional support animals, the law says that the applicant, the tenant, has to provide a letter from a fully licensed, certified mental health professional who will write that letter to the landlord saying, Mrs. Tenant is a client of mine, is a patient of mine. I'm treating her for the following mental disorder, and I am prescribing the use of fill in the blank here, boa constrictor, peacock, cat, whatever, which I consider to be essential for her ongoing mental health treatment. And if you get that ESA letter, emotional support animal letter, then they also are protected under the federal act. Okay, of course, those are the federal laws. As I said, the local government has the right to add to those, in which case you would want to follow your state or county rules, but you can't ever pick the lesser of the two. All right, let us move on to advertising. And the easy way that I would suggest you think about advertising is simply to focus on the apartment, focus on the unit, not on the type of people that might be interested in living in the unit. You saw on that poll that we just took the ad saying it's walking distance to the synagogue. That's maybe absolutely true. But the inference there could be taken to mean that if you're not Jewish, then you won't fit into this neighborhood. So HUD actually on their website has some really great examples of the types of words you can use and the types of words that you cannot use when it comes to advertising. And it's far better to spend 20 minutes now learning those than to spend $20,000 with an attorney trying to defend yourself. It tells you, for example, that a mother-in-law suite is a perfectly acceptable advertisement term, whereas other things such as talking about the safety of the neighborhood may not be. So the best advice I have is to check with the website. All right, let us then talk about the ADA, the Americans with Disabilities Act. You only have to be concerned with the ADA for commercial or public access premises, such as a restaurant, an office building, the county library, things like that. And the Americans with Disabilities Act is a very broad law. It covers protection of persons with disabilities in employment, in access, as I say, to those public areas, and it doesn't apply at all to residential housing units. So it's not something that you're likely to have lots and lots and lots of questions on your state exam. All right, well, speaking of ADA, let's take a quick look at some questions that we have for you here. As I say, only have to worry about commercial facilities and places of public accommodation. All right, so our next poll question is, which of the following is a true statement regarding the requirements of the Americans with Disabilities Act? Okay. Well, the two most popular answers, we're bumping up there, D, are ADA requires landlords to make reasonable modifications at the request of the disabled tenant. That is absolutely true if it's an ADA covered property, such as an office building or the police station, the public library, the town hall. And the other most popular answer was D. ADA does not regulate rental units on privately owned properties. That's absolutely true, assuming that what we're talking about here is privately owned residential properties. If you privately own a 4-story office building, then certainly ADA does regulate that. So good job. You hit on the most important points there. All right, let's go to the next question as we in our final moments. Which of the following would be deemed a reasonable modification for a lessor to make on behalf of the lessee's request. Okay. And I thought the A's were going to catch up to the B's there for a moment, but the B's are the killer bees, and you killed it absolutely. You could really argue A or B as being a relatively inexpensive and reasonable modification for the lessor to make. It is generally feasible for the landlord to say, I'll go ahead and make that modification if the tenant pays for it, and it can even hold in escrow the same amount for it to be restored to its original condition when they move out. But certainly adding grab bars is a relatively inexpensive and certainly meets the definition of quote unquote a reasonable modification. All right, well, where do we go from here? What do you expect to do once we get a little further along? There could be a question on the Equal Credit Opportunity Act. What is the Equal Credit Opportunity Act? You tell me what you think it is. And drum roll, please. With 90% of the people picking A, you are absolutely right. A property manager should treat all applicants exactly the same way. There should be one application form for all people, regardless of what they look like, what they sound like, where they come from, how they pray. A standard application form is the best way to stay out of trouble when it comes to the Equal Credit Opportunity Act. Good job. All right, well then let's move on. And where do we go from here? First of all, when you do your state exam, don't be surprised if you find that there are more questions than you've been led to expect there will be. It's very common for the testing service to go ahead and throw in anything up to 10 questions that they're experimenting with. When you take those questions, the clock will stop, so you won't be timed on them, and regardless of whether you get them right or wrong, then it won't affect your overall score. So that being said, let's move on to the next slide, in which I will ask you to go ahead and check your candidate guide that is produced to give you every conceivable answer to your question. It will give you what the passing score is, the breakdown of the questions, and so on and so on, and is a really valuable resource for you to use. All right. Well, I've enjoyed being with you today. Let me ask you now, what questions do you have about what we've talked about today? Please don't be shy.
Thank you, David. We will go ahead and take some time now for some questions. Just a reminder for those of you joining us, please be sure to share your questions in the Q&A box in your control panel. And it does look like we have a few. We do have a few requests to revisit some of the ADA content in those last few slides, David, and what constitutes a reasonable accommodation. Would you mind going into the ADA compliance just a little bit more?
Sure, absolutely. So again, with the caveat that ADA does not apply to individual, residential units. It's really for commercial and for places of public accommodation. A landlord is required to make a reasonable modification. For example, let's say that an applicant for housing is on crutches, and the landlord is asked by the tenant, the prospective tenant, I'm going to have a really hard time walking from the other end of the parking lot to my unit. Would it be possible for me to have a reserved parking space close to the door? That certainly would be considered a reasonable accommodation. Or I have a hard time getting my wheelchair up the curb here. Would you please put a ramp there for me? Or as you saw one of the examples, a grab bar in the bathroom so that I can easily hoist myself in and out when I need to use the facilities. Those would be considered reasonable accommodations or reasonable modifications. The landlord is not expected to have to bear the cost of that herself. The landlord has every right to say, sure, I'll do that, but I've gotten 3 quotes and it's going to cost $1,500, and to have the tenant pay for that. Again, as I think I said to you before, they also have the right to say, well, what if that tenant disappears 2 days before their lease ends? I'm going to have to pay for that all to be undone. The landlord has the right to say, let's go ahead and hold the amount in escrow to have it restored to its original condition. Okay, good question. Next.
All right, looks like we've got a few more here. Are there certain companies or templates that you would recommend putting leases together?
I missed the first word. Are there certain what?
Companies or templates that you would recommend for putting leases together?
Oh boy, I would say the most important thing there is to check with your broker, because in many states, it's considered to be the unauthorized practice of law for you to just sit there at your laptop with a Microsoft Word blank page in front of you and start typing up a lease. So check with your broker. In most states, the chances are that there is a fairly standard residential lease form that your state board of realtors has adopted, or that the brokerage that you're joining has, and they are essentially fill in the blank forms. So you don't need a law degree to be able to fill in a blank that says name of landlord, amount of rent, when it's due. So that's what I would absolutely do. I wouldn't dream of trying to go and make up my own lease. Yeah, and it's free. Free is good. So you'll get that right from your broker.
All right, thank you. We do have another question about the exam. How much of the exam will be on property management?
Again, it really depends on the individual state. The good news is it's usually a very small percentage. I think when we first started today, you saw that it says property management and leasing is 3%. Some states, it may be more than that on leasing and less than that on property management. I will say, in my experience from taking both salesperson exams, broker exams, and instructor licensing exams, that usually there are very few questions on property management. It really is a separate discipline. Is a real estate agent allowed to conduct a property management operation? Yeah, in most cases, but it tends to be something where there are specialized people that do it. Again, I would really urge you, it's kind of an interesting business. It's certainly not 9 to 5, as you could imagine, but it's a fairly stable business. But I would urge you before you decide to just go out and start winging it, doing a little property management on the side for that client that you sold a rental property to. Check with your broker, because some states may require extra licensing, and many brokers will tell you that their errors and omissions insurance policy does not cover you if you as an individual agent go out and start doing property management, as they say nowadays, on a side hustle. So just a general suggestion, always talk to your broker first.
And that's actually a great segue. We have a question from Jaron. Any tips on how to find a good broker?
Oh boy, now you're going to get me into so much trouble. Yes, I do. Because we're an independent school. And so, one of the things that we pride ourselves on is not pushing any one company. I think the most important decision that you could make is to choose a broker that has really outstanding training right from the gate. Now, I don't want to make this a 20-minute answer, so forgive me if I truncate it as much as possible, but I feel so passionately about this. I have seen over my 30 years in the business so many agents that are bright, super enthusiastic people, and they join a brokerage, and essentially the broker says, "Hey, I'm so glad you joined us. That's great. Hey, everybody, this is Karen. Hey, Karen, there's a desk, there's a chair. Call me if you have any questions. All right, bye." And 3 months later, Karen's out of the business because she hasn't had a single listing or a single buyer. So my suggestion is you don't just be satisfied with the first answer that the broker gives you, because I jokingly say to the guests in our school that to get hired by a real estate broker, you have to pass the breath test. And they usually look a little askance. And I say, no, not the breathalyzer test. The broker will put a mirror in front of your nose. And when he takes the mirror away, if he sees breath on the mirror, they'll offer you a job. But that is, you should be interviewing the broker, not the other way around. And what you should say is, what kind of training do you have? There's not a broker on the planet that isn't going to say, we have great training. But don't be satisfied with that. Say, okay, could you please show me your training calendar? Do you have a professional trainer, or is it just existing agents that you try to strong arm into doing a training session once in a blue moon? Can you show me exactly not only how to get from zero to my first $2 million in sales, but what about 3 years from now when I'm doing $9 million a year? What kind of training and coaching do you have to get me from 9 million to 20 million? You see what I mean by burrowing down to the next level and the next level and the next level? Absolutely critically important. I think personally way more important than just commission splits. Don't just go on the commission split. I know companies in our area that have 100% commission splits, and they cannot keep an agent because if they're giving it all away, where is the money for them to have training? The second and final thing that I think is really important is the culture. And you can sense that. It's sort of like going into a restaurant. You can just feel it, that there's something special. And you want to go with a company. I won't mention the company that I'm with, but I came from spending years with a company where the culture was so what can I say, so jealous that you couldn't ask anybody a question because the other agents would say, well, I'm not going to tell you that because you might go into competition with me because we're in the same office. The very day that I joined the brokerage that I'm with today, although I'm not actively selling anymore since I'm teaching so much, the very day that I joined them, I was going to do an open house on a Sunday. This was a Friday, and I went to one of the other agents and I said, where are the open house sign-in forms? And he said, well, we don't actually have them as a company, but here, let me give you mine. And I've seen over and over and over again people say, hey, listen, I'm so glad you're with us. Tell me what I can do to help you. Would you like to come under my wing? Would you like to shadow me at a listing appointment this week? Would you like to come with me so you can see how I do open houses? And that's what I mean by the culture. To me, that's way more important than how big the name is, or how close they are to my home, or whether I get a 70% commission split or a 65% commission split. I hope that helps.
Thank you, David. It does look like we've covered all of our questions. David, is there anything else that you'd like to add before we wrap up?
Well, 32 years ago, I was sitting right where you all are sitting right now. And some of the things I just remember thinking, oh my gosh, my brain hurts. I just don't get this stuff. And yet I got through it. And 32 years later, I'm still friendly with my instructor from that time. 32 years later, I'm still good friends with a couple of people that were in the real estate class. Real estate has been such a fantastic career for all kinds of reasons, and I hope you understand this. I always get scared when people say on the first day of class, the reason we're going to become realtors is because we love watching HGTV. And I shudder, because it's not like that. In 22 minutes, you don't go and find the perfect two clients who look at three perfect houses and then put in a perfect offer almost at list price. It's not, and then you get a $20,000 commission. But what's more important is, yes, you'll have the ultimate flexibility to go and watch your daughter's piano recital, to watch your son run track if you want to. You don't have to ask permission, but you can never get fired. Look at 40 million people unemployed right now, and every real estate agent that I know in our area is going like gangbusters. The only way you can get fired is if you fire yourself. And finally, the unbelievable satisfaction that you'll get from helping people in their hour of need. They're first-time home buyers looking for a home, the little old lady that's selling the house she raised her kids in to go to a nursing home. And those are the moments that you will remember. So good luck with that. Just remember, you are in the best customer service profession in the world. Good luck, everybody, with your exam and your careers.
Thank you so much. And thank you, everyone. We appreciate you being here. I'd like to thank David again for joining us today. Your knowledge, expertise, and willingness to share it with our student community is greatly appreciated. Everyone look out for an email from us with this presentation, and keep an eye out for invites to additional webinars in the near future. And once this webinar ends, you'll have the option to fill out a survey. If you're able to take a minute, we'd love your feedback so we can continue to provide valuable webinars to you. Thank you again for joining us today, and we'll see you next time.